Welcome, and thank you for joining us today for our webinar on New York State and City Employment Law, 2023 Year in Review, and what's to come in 2024. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature on WebEx. However, if your question is not answered during the session, our presenters will follow up with you directly in the coming days. For those of you interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and it is required for CLE credit. Copies of the webinar recording and presentation materials will be distributed to attendees following the presentation. A quick disclaimer, this presentation has been prepared by Seyfarth Shaw for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. At this time, I'll turn it over to Rob Whitman.
Thank you, and hello, everyone. Good afternoon to those of you on the East Coast. Good morning to those of you farther west. We're very pleased to have you with us today to discuss a year in review on New York State and City employment law and a look into the crystal ball for what we can expect in 2024. You can see on your screen the roster of our presenters. We have a large group today because there is a lot of subject matter to cover. It's been quite an active time over the last year, and we expect an equally active year coming up. Next slide, please. Here is our agenda, but let me just, before we get into the specifics, let me just give kind of a brief overview of kind of what the landscape is in New York State and New York City. We don't usually cover politics in these webinars, but some appreciation for the political landscape is helpful to understand where we are, where we're going in employment laws in the area. New York State and New York City are two of the most employee-friendly jurisdictions in the country, certainly giving California a run for its money if we have not already exceeded it. And we will actually have a little peek into New Jersey as well today, which is doing its best to keep up with its neighbor to the east in New York State. New York State is one of 40 states in the country that has a trifecta in its state government, which means the same party controls the governorship and the two chambers of the state legislature, but it's one of 17 in the country that has Democratic Party control of all three branches. Governor Kathy Hochul is now serving her first full term as governor after being recently elected in her own right. She was lieutenant governor previously. The state assembly and state senate both have supermajorities of Democratic control. The numbers in the assembly are 102 Democrats to 48 Republicans, and in the Senate, 42 Democrats to 21 Republicans. That creates fertile ground for new legislation in the employment law area, which is one of the priorities of the party in control. And so that's part of the reason why we see as much activity as we have. In New York City, also full Democratic control. Mayor Eric Adams is in office, and the city council has a ratio of 45 Democrats to 6 Republicans. So a strong supermajority there as well. Against that background, here's what we'll be covering today. First, I will do a brief look into some wage and hour developments that have occurred. Then we will get into artificial intelligence. You've probably been hearing and reading quite a bit about artificial intelligence in all kinds of ways over the last year or so, but the workplace is one of the hottest areas for application of that topic that we all need to make sure we stay conversant with. Pay equity remains an active topic here in New York as well as nationally, as well as is paid leave. So we'll be covering both of those subjects in some depth. And then we will have what we're calling our lightning round, which is a rapid fire discussion of a host of new developments, many of which you may have heard of, but I'll bet some of which you haven't. And so hopefully we'll keep you, make you aware of those, at least give you some look into what's been going on in those areas. And certainly we'll share that, as was mentioned, we'll share the slides with you after the webinar is concluded, so you have all of that as an easy reference. Next slide, please. So first discussion will be wage and hour developments. Next slide. And the first topic, which hopefully you're all aware of if you have operations in New York State, is the change to the minimum wage. We continue to have in New York State a dichotomy between the downstate counties in New York City, Long Island, and Westchester, and the remainder of the state. We have hit $16 an hour for 2024, and you can see the slated increases over the next 2 years, both in the downstate counties as well as the remainder of the state. Next slide. Along with the increase in the minimum wage have come increases in the minimum salary required for exempt status in New York State. And again, there is the dichotomy between downstate and upstate. In 2024, the threshold is $1,200 a week for the downstate counties and $1,124.20 in the remainder of the state. We've given you the annual salary numbers, the annual salary equivalents, but really it's the weekly salary that is important because for exempt status, an employee must be paid that minimum on a weekly basis rather than going by an annual salary. So to the extent you have not yet adjusted salaries for those who are close to the border in terms of exempt, non-exempt status, you want to make sure you take a look at that as soon as possible. Next slide, please. So the next subject in wage and hour is one that is a litigation-focused subject, and it concerns weekly pay for manual workers. Section 191 of the New York labor law provides, as it has for many decades, that manual workers must be paid on a weekly basis unless the employer has a specific authorization from the State Department of Labor to pay less frequently than once a week. In 2019, the first department, which is the appellate court in the New York State system that covers Manhattan and one or two other counties, held in a case called Vega that a private right of action is permitted under that statute. Previously, there was no private right of action permitted. And along with the private right of action came the ability to obtain liquidated damages for failure to pay wages on a weekly basis. And so what that did was open the floodgates of litigation for claims by manual workers for violation, potential class actions by manual workers for violation of that obligation, and the opportunity to obtain liquidated damages equal to the full amount of delayed wages. Enormous potential exposure for employers who were not paying manual workers on a weekly basis. Just a few weeks ago, the second department, which covers Brooklyn and Long Island, in a case called Grant, explicitly disagreed with Vega, held in a split decision that Vega was wrongly decided and that there is no private right of action under Section 191 of the labor law for the weekly pay requirement. In the Grant case, the plaintiff's counsel has already filed a petition for review by the state's highest court, the Court of Appeals. It seems certain that the Court of Appeals will weigh in on this. It had not done so ever in the almost 100 years or so of the existence of the statute. The Vega case itself was settled after the appellate decision, so there was no opportunity for further review. So we expect some review and some decision by the state's highest court, which will resolve the issue definitively sometime in the next year or year and a half. There have been two recent federal court decisions that have, including one that was just issued a day or so ago, in which the federal judges have opined that they predict that the Court of Appeals will follow Vega rather than Grant, although they acknowledge the split in authority. We will be watching this quite actively and with great interest to see how the Court of Appeals resolves it. In the meantime, Governor Hochul has proposed in her 2025 budget an amendment to the labor law, Section 198, which is the remedial section, that would state that liquidated damages are not available for violation of the weekly pay obligation. If that proposal is enacted into law, then that would resolve this issue once and for all. The Court of Appeals ruling would be moot at that point, or at least would only apply retroactively rather than prospectively. So we will be keeping an eye on that budget proposal as well to see if this remains an active area of the law. Next slide, please, and I'll turn it over to Joe for a discussion of artificial intelligence.
Great, thanks, Rob. So as Rob mentioned earlier in the introduction, we cannot get away from this discussion about artificial intelligence and how it's not only impacting the workforce, but just day-to-day life. But specifically today, we're going to discuss not only New York City Local Law 144, which was enacted last year with enforcement beginning in July, but also some developments that may come to fruition throughout the course of 2024. So before we get into those developments, we wanted to lay out for you the current state of the use of artificial intelligence in the workplace. So on the next slide, you'll see that in November of 2023, SHRM put out a state of workplace research survey, and based on the companies that responded, you'll see that 25% of HR departments are currently using AI today, whereas 26% of those plan to adopt some sort of AI in their organization throughout 2024 and then thereafter. Specifically on the next slide, you'll see that breakdown where, there we go. Of the 26% planning to utilize some sort of AI technology in the workplace, 15% plan to adopt that in 2024, where 11% anticipate essentially using it beyond that time frame. So by 2025, we could almost have 50% of employers using some AI in their workforce to make their jobs easier, to recruit, to source for performance. But an interesting stat from this survey is that while these technologies are still being introduced, largest organizations are still leading the way in actually utilizing them. So 38% of what they call extra large organizations with 5,000 employees or more are currently using AI technologies, and it's being driven by the IT, data processing, and software development industry, as well as the financial, insurance, information, and real estate industry. But we could certainly expect that to grow as more and more offerings are made to employers and could create efficiencies within their company. But as we all know, with efficiency also comes additional risk. So before we dive into the potential legislation and regulations that might be coming, how are AI technologies currently being utilized in the workforce? So on the next slide, here's just a laundry list of ways in which this is being used currently. So of course, we mostly hear about sourcing and passive searches for talent, skills and job matching, so that we could determine who might be the best fit for the organization for a particular role or opening at the company. They also have the capacity to evaluate resumes and interview candidates, score candidates on those interviews, assess and create assessments and gamification tools, all these types of ranking systems, communications with chatbots to improve candidate experience when they're applying for openings, additional communication technologies so that applicants aren't left in the dark about the status of where they may stand in a particular selection process. They also have the capabilities out there to now assess skills gaps, to assess performance and performance management techniques, and then some predictive technology about what might drive individuals to leave the company, as well as performance issues while people, are there's constant absence issues or workflow issues. There's all these technologies out there that are being marketed and adopted by companies. So moving on to the next slide. As I mentioned, New York City Local Law 144, which was the first of its kind, was adopted in January of last year, but did not go into enforcement until July 5th of 2023. And what New York City employers are required to do is they're prohibited from using any type of artificial intelligence technology. The term of art they are using is automated employment decision tool, unless that tool underwent a bias audit within 1 year before use, and that certain notice requirements are provided to employees and candidates if the AEDT is being utilized in the selection process. At a minimum, those bias audit requirements have to include certain demographic information. So we need gender, race, ethnicity, and the intersectional categories of those two groups. We also, the audit has to be conducted by an independent auditor. We have to test for disparate impact before that use. We have to publish the results on our career website and then conduct tests annually to ensure that more new refreshed data is being assessed on that annual basis, so we could see what that impact might be to those that are undergoing the testing. Notice must also be provided 10 days before the AEDT is used, along with any instructions for requesting an alternative process or accommodation. That is the New York City law in a nutshell. There are nuanced provisions within that law that we're not going to go through today, but currently this is what New York City employers are faced with. But keep in mind, this applies to those positions in the city. So if you have a position open in New York City and an AEDT is going to be utilized, then this bias audit must take place, notice must take place. But I'm sure internally you're already having those conversations before implementation of, if we're using a tool, does it constitute machine learning and AEDT under the New York City law? If so, here are all the additional obligations that we must comply with so we don't run afoul. So if we move on to the next slide. Before we dive into the state-related developments, there was a rather new development in the federal contracting space. So for those of you out there that work for federal contractors, the Department of Labor's Office of Federal Contract Compliance Programs, they've had a set of FAQs on their website on how they approach the use of artificial intelligence in any employment decisions. However, in August of 2023, they released an updated scheduling letter. So for anyone taking government money over a certain threshold, they're subject to OFCCP's regulations and are also subject to audit. If selected for audit, now what OFCCP is requesting in that letter is information and documentation of policies, practices, systems used to recruit, screen, and hire, including those of artificial intelligence, algorithms, automated systems, or other technology-based selection procedures. A very broad request, but it is also showing the federal government's direct interest in the utilization of these technologies to ensure that they're not having discriminatory impact on the pool of candidates or employees in which those tools are used on. So in addition to the federal requirements, we do also have some state developments that, while very, very fresh, very new, we want to make you aware of. So this will create some tension with companies because there's not a one-size-fits-all approach to how states are going about governing and regulating artificial intelligence and the way it is used. So it's going to continue to be a very active and complex process for employers throughout 2024. Specifically, what we're seeing is for New York State, excuse me, there's bill introduced Senate Bill 5641. And what's interesting here is that they are taking a bit of a different approach than New York City did. The state is ultimately discussing artificial intelligence and putting responsibility on both developers and deployers, they call them, of these technologies. And so this is something where it's not going to necessarily be just the employer utilizing the technology, having obligations to comply with whatever the final rule and law might be, but also the developers of those technologies to ensure the systems and processes are being developed in an ethical way. What New York State Senate Bill 5641 also does is they define automated employment decision tools differently than the New York City law, and stated that they define it right now as a system or service that uses artificial intelligence and has been specifically developed and marketed to, or specifically modified to be, the controlling factor making a consequential employment decision. What you'll note there is it narrows that scope. It's trying to eliminate the loopholes that are in the New York City law, because one of the main complaints that we're seeing in news articles and things is that the way the city drafted their measure, it gives employers a lot of flexibility to interpret what that AEDT is, to come down and say, you know, we're not using one because as a whole, on balance, this factor that the tool is providing us isn't the ultimate factor in making any type of selection decision. The New York State bill is trying to close that loophole, and also has some other pretty interesting provisions as drafted. So, if enacted in its current state, this piece of legislation would ultimately preempt New York City law, because it states that a deployer or developer that complies with this article shall be deemed compliant with any law, regulation, rule, requirement, or standard related to the performance of an impact assessment, audit, or governance program, or the equivalent of an automated employment decision tool that is adopted, maintained, or enforced by a political subdivision of New York. So we still have to see how this shakes out. It's only at the introductory phase. It's in committee right now, but I am sure that will gain traction in the upcoming year. The other interesting provision within the proposed bill is that any impact assessment can be requested by the New York Attorney General, and they also state that the disclosure of this impact assessment to the AG would not waive privilege. Connecticut also has a bill that's been introduced. There's a hearing tomorrow on it. It's somewhat of an omnibus AI bill. That's what we would call it, because it contains a variety of different aspects of artificial intelligence. But to note, they also adopt this developer and deployer language and framework. So we will also track that closely to see how, what might become enacted in Connecticut as well. So with that being said, employers have to have these constant conversations, not only internally, but with their vendors that they might be looking to outsource this technology from. And HR professionals in particular need to have a seat at the table to ensure that the concerns that are coming down the pike in these multiple jurisdictions are addressed early on in the decision-making process. So here's some questions to keep in mind before implementing artificial intelligence that you may want to consider. Most importantly, does the tool work? Is what is being advertised actually occurring on the back end when the tool is implemented or tested out? How has the vendor employer demonstrated that the tool does what it says it does? What has the vendor employer done to analyze potential bias against protected categories? What is the scope of the analysis? How does it play out within your organization specifically? Do you as an HR or business professional have the technical expertise to assess the vendor's representations? Oftentimes you might not. However, make sure that you have the proper departments and personnel in those conversations in order to help you with the decision-making process. And lastly, what structures does your organization have in place to evaluate the benefit and risks of artificial intelligence, and what resources and processes do you have in place to identify and manage those risks?
Okay, great. Now we are going to be moving on to the New York State and New York City pay transparency laws as part of our pay equity topic. We could go to the next slide. Now, before diving into the specifics about the state and city laws, we wanted to give you a general overview of the landscape here. So these types of wage range disclosure laws have been popping up over the last few years, and we expect that they will continue going forward. And they really fall into three buckets, these types of laws. There's the laws that require disclosure on job postings. There's ones that require disclosure at some other point during the application process or for employees in their current employment relationship. And then you have laws that require disclosure upon a reasonable request. So the laws that are listed here are the current laws that are in effect nationwide. And it's important to keep these kind of the total picture in mind as you're thinking about the New York laws in relation to a national perspective, because a lot of these laws will apply if you have just one employee working remotely in that jurisdiction. So as you're considering the New York laws, it's important to keep these in mind as well, to kind of come up with a total approach for your operations. I'll note that New York City did have a bill introduced in the last legislative cycle that would have expanded the New York City law to disclose other forms of compensation and not just base compensation. And it would have also required disclosure to current employees. And we'll get a bit more into the specifics of the New York City law, but I wanted to note that kind of as part of keeping an eye on things going forward for 2024. We'll see if a similar bill is introduced going forward, but that was what New York City had considered in the past year. Other laws to keep an eye on are Virginia and Washington, D.C., which are being considered by the governor and under congressional review right now. We can move on to the next slide. Okay, so diving into the New York State pay transparency law. So this law went into effect on September 17th of 2023. It requires employers to disclose in an advertisement for a job, promotion, or transfer opportunity the compensation or range of compensation for the position and a job description if such job description exists. It also defines advertise as making available to a pool of potential applicants for internal or public viewing. It includes electronic postings, and it's a written description of an employment opportunity. And something that's unique about the New York State law is that it applies to advertisements for job promotion or transfer opportunities that will be physically performed, at least in part, in the state of New York. And New York has considered opportunities that will be physically performed outside of New York, but reporting to a supervisor, office, or other work site in New York as also part of the types of advertisements that would have to disclose the required information. And this is unique about the New York State law. I had mentioned some of the other jurisdictions. They look at whether you have just one employee working remotely in the state, and if you are posting a remote position that can be performed anywhere, you might have to comply with that law. And New York State does things a bit differently here. There's some challenges with figuring out whether the job will report to a supervisor, office, or work site within New York, but we'll talk about the proposed regulations that give us a bit more clarity on that. One other note about the New York State law is that it does not apply for job advertisements for temporary employment at a temporary help firm. So this would be if a staffing agency is posting a position to be filled at an employer. Those are separate to, subject to separate requirements under the New York State Wage Theft Prevention Act. So those are not covered by the New York State law. And that holds true for all of the New York laws. We could go on to the next slide. Okay, so I had mentioned that New York State has put out proposed regulations. These were put out a few days before the law went into effect, and they have gone through a comment period, but the final regulations have not been issued yet. But I'll go through here just a few of the key takeaways from those proposed regulations. The first point here is that infrequent presence in New York will not be enough. So the law says that if you are performing the role in part in New York State, or if it's expected to be performed in part in New York State, then you'll need to disclose the pay range. But the guidance states that if an employee is just going to a few meetings in New York, and that's what you're expecting for the role, then the posting for that role will not need to comply. The guidance also states that the law applies when a temporary help firm is hiring its own employees. So if a hiring manager at a temporary help firm is hiring an executive assistant to work at that firm, the advertisement for that executive assistant position would have to comply with the New York law. The next point here is that advertisements are covered regardless of medium, so long as they are sent to a pool of applicants. And the guidance specifies that a pool of applicants means more than one potential or prospective applicant. And also the second point here is that employers are responsible for advertisements posted through third parties. So if there is a website that is taking your postings and publishing them for the employer, then you will be liable for those postings. The caveat here is that there is an exception for advertisements that are scraped or automatically aggregated electronically and then posted to a third-party site without the employer's knowledge or consent. In that case, the employer would not be responsible for those advertisements. We could go on to the next slide. Okay, up one back, please. All right, so then the pay range under the proposed regulations would be solely the base rate of pay, so it does not include other forms of compensation. Another unique part about the New York State law now, based on the proposed regulations, is that the pay range must be for a single opportunity and a single geographic location or region. So that means if you have a different pay rate that you expect to pay somebody for a position in New York City than you would pay somebody who is performing the role on Long Island, you would have to include in the posting both that New York City rate and the Long Island rate. Same thing for if you have a posting that can be performed anywhere in the United States, including in New York. If they're reporting to a supervisor in New York, then you would have to include each separate pay rate in the posting to specify the New York rate. The proposed regulations also specify that the pay range cannot be open-ended, so you can't put in $20 an hour plus. Employers' use of hyperlink to provide pay range may also be restricted based on the proposed regulations. So the proposed regulations state that if the pay range information is kind of too unwieldy to put into a job posting, you might have character limits in a job posting and you can't put in that full pay range information based on geographic location. You can then link to the pay range information. But based on that guidance, it seems that if you just have a normal rate that you're putting in that would not be as burdensome, then you would have to actually provide it within the job posting. Also, the posting of a good faith range means the range of compensation the employer legitimately believes it is willing to pay the successful applicant or employee at the time they post the advertisement. So the proposed regulations make clear that what matters is at the time that the advertisement is posted, what you expect to pay for that role. That may later change, but it's based on what you expect at the time. Okay, next slide. So a few points on what's still not clear based on the proposed regulations. The first here is what level of detail is required for a job description in an advertisement. There's no real guidance on this. The only guidance is that if you have a job that it's clear based on the language, based on the job title, what the job is, you wouldn't have to include a job description. For example, if you're posting for a dishwasher and the job is only doing dishwashing, you could just describe it in that way. Otherwise, there is no additional guidance on that. The second point here is who constitutes a supervisor in New York. I'll note that there is an example in the frequently asked questions that were also published by the Department of Labor here, which makes it seem like the agency is taking a bit of a broader view of who would be a supervisor. So it states here, I'm posting for a remote job opportunity. The individual who directly supervises this position works remotely from their home in New York State. And then it explains that the company is located outside New York. Leadership team and offices are located outside of New York as well. Do I need to comply? And the guidance says that the answer is no, which is interesting because it talks about the direct supervisor working in New York, whereas the rest of the leadership team outside of New York. So this gives us a bit more clarity in the FAQs, but also kind of raises more questions than answers, as well as to how this is all going to be interpreted for reporting to a supervisor in New York. Okay, next slide, please. Just in terms of potential exposure and penalties, any person can file a complaint with the Department of Labor. There's no private right of action, and these are the civil penalties that are available. Next slide. I will quickly go through some of the New York City obligations as well here. So in New York City, it's an unlawful discriminatory practice to post an advertisement without including the minimum and maximum salary for the position. The law applies to employers with 4 or more employees as long as you have 1 employee in New York City. And again, it does not apply to job advertisements that for temporary help firms. Next slide. Some of the key takeaways, again, as long as you have 1 employee in New York City, the law is going to apply. And this is from the New York City Commission on Human Rights fact sheet here. These are kind of key takeaways from that fact sheet. The salary range is the lowest to highest salary the employer believes at the time of the posting, again, that it would pay for the position. Next slide. So this is a key difference between the New York City and New York State law. In New York City, any remote work that could be performed in New York City, as long as you have 1 employee in New York City, you're going to have to comply with the law. Next slide. Again, the salary range can't be open-ended, and you are only required to disclose the base salary or wage rate. Next slide. Now, potential exposure and penalties under the New York City law is a bit different. There is a private right of action available for employees, but not applicants. And both applicants and employees can file a complaint with the Commission on Human Rights. And I'll note that the Commission has been active over the past few months with kind of putting out a round of violation notices that it's sending to employees and complaints that employers are having to respond to now. So if you have any questions about your compliance with the New York City law, it's a good opportunity to get in there and correct it before any such violation notice comes to you. Monetary damages, there's potential affirmative relief, and civil penalties up to $250,000 for an uncured first violation. Now, the law provides that the commission will not assess a civil penalty for a first violation as long as the employer shows it's fixed the violation, but that submission of proof that you fixed the violation will be deemed an admission of liability, such that if you are flagged again a second time, that $250,000 penalty will apply then. Next slide. And a quick note on the other New York laws. There's Albany County and Ithaca that also have pay transparency, wage range disclosure laws in place. They largely track the New York City law in those jurisdictions. And Westchester County had also had a law on the books, but that became null and void when the New York State law went into effect. Okay, now I'll pass it on to Ashley.
Awesome, thank you. So moving on to the next topic, I'll be covering the paid leave section of today's webinar, starting with everyone's favorite, the New York City Earned Safe and Sick Time Act, otherwise known as ESTA. So starting off with a little bit of background, ESTA is very similar to the New York State paid sick leave law in that it requires employers to provide New York City employees with 1 hour of leave for every 30 hours worked. And employees can accrue up to 40 or 56 hours, depending on employer size, which can then be used for health and safe related reasons. But of course, keeping us on our toes, on October 15th of last year, the final amended regulations went into effect, which kind of add a wrinkle into this mix. So we can start going through them on the next slide. So starting with employer size, it's now clear that employer size is determined on a nationwide scale, meaning if an employer has 100 or more employees nationwide, even if they only have a handful in New York City, it must provide those New York City employees with up to 56 hours of leave per year. Conversely, if they have 99 or fewer employees, only up to 40 hours are required. But don't be too concerned about this because the New York State law already required employers to consider employers' entire US workforce for sick leave purposes. So that's not a huge change. But what may prompt a change is the new accrual programming requirements under the amended regulations. So according to the rules, accrual of safe and sick time must account for all time worked, even if the time worked is less than a 30-minute increment. So this means New York City employers must round accruals to the nearest 5 minutes, 1/10 of an hour, or 1/4 of an hour, according to the rules that's explicitly listed. So this can definitely place an administrative burden on employers, but it's definitely important to make sure that we're capturing all time worked by employees and then rounding up or down appropriately. And according to the final rules, an employee who performs work in another state, such as New Jersey, is also covered by ESTA so long as they regularly perform or are expected to regularly perform work in New York City. So this is a little bit of a change. And in this case, only the hours worked in New York City will count for accrual purposes. So we have to know at some point they're going to end up in New York City. We can move on to the next slide. So now moving on to reasonable notice procedures. So the amendments added a definition to foreseeable leave. So before this, we would typically say that leave is foreseeable when an employee has a scheduled surgery, a doctor's appointment, or something like this. But now the rules state that leave is foreseeable only when the employee is aware of their need to use the leave at least 7 days in advance. So 7 days is now the magic number that we should associate reasonable notice with. And it's also important to note that the amended rules further clarify what constitutes reasonable written documentation under ESTA. So previously, ESTA just listed documentation from a licensed healthcare provider as reasonable, which is extremely broad. So now the rules provide additional examples, including documentation signed by a licensed clinical social worker or a licensed mental health counselor. So if an employee provides documentation signed by these individuals, it must be accepted under ESTA. Next slide, please. Another change is the balance notification requirement. So before the amended rules, employers were just told that they had to notify employees as to their accruals, usage amount, and balance by some type of written document, which could be payroll. But now, under the amended rules, employers can use an electronic system to comply with the balance notification obligation, which makes things a little bit easier. But the twist is 3 requirements must be met before employers can use this electronic system. And that includes the system must send out electronic alerts to employees, the system is accessible outside of work, and the required information is available on the system for past pay periods as well. So if one of these 3 are not met, then under ESTA, the electronic system would be deemed non-compliant. So that's just something to keep in mind as well. Next slide, please. And of course, the amended rules also added additional written policy requirements, which are listed here on the screen. And we strongly recommend that you reach out to your Seyfarth contact in case you're unsure if your policy is not up to date with the new ESTA amended regulations, just because the Department of Consumer and Worker Protection, which is the agency who enforces ESTA, is extremely aggressive in enforcing violations. And the written policy is something that they commonly request and will look at first. So we just want to make sure that that's as compliant as possible. And a quick reminder here about rate of pay. Under the amended regulations, employees must be paid at their regular rate of pay at the time the leave is taken. And this amount can't be less than minimum wage or as required by CBA. So we just want to look at the wage that they're earning at the time they use the leave. Next slide, please. And a few final points about ESTA here. Another important point is successor employers. So now successor employers can be held individually and jointly responsible for the original employer's ESTA violations. So it's another reason to make sure that we're being as compliant as possible with these amended regulations, as well as the law in general. And of course, penalties for non-compliance with the law are even more problematic for employers. So aside from the reasonable inference standard, which is extremely employee friendly, employers can now be held liable for $500 per employee covered by the ESTA policy each calendar year, even if they leave or are separated for some reason during that calendar year. So this can definitely add up, especially if the employer has hundreds of employees. Next slide, please. So now that we're probably sick of ESTA, we can move on to another fun topic, which is COVID leave. Next slide, please. So some of you may be surprised to learn that the New York State COVID-19 emergency leave law is still in effect. And because the law is alive and well, we can quickly run through some of the requirements just as a refresher. So the amount and type of leave employees are entitled to depends on employer size and income, which is listed here. The 2 most common are the second and third bullet points. So for example, employers with 11 to 99 employers or less, if they have a net income of $1 million or more, must give employees 5 days of paid COVID leave. Whereas if you have 100 or more employees, you must provide 14 calendar days of COVID leave. Next slide, please. And in terms of reasons for use, it's important to keep in mind that COVID-19 paid leave is only available to employees who are subject to a mandatory or precautionary quarantine or isolation per the New York State DOL guidance, which is constantly changing. But there are some limitations to the law. So employees can only use this leave for a total of 3 times. And the second and third times must be because the employee tested positive for COVID. The first time can just be in case they were exposed to COVID-19. Next slide, please. So the first time an employee uses COVID-19 paid leave, the employee must be allowed to provide any type of documentation listed here, including a self-affirmation, which, as a reminder, does not need to be notarized. However, for the second and third times, like we just went over, COVID-19, they have to have tested positive for COVID-19. So employees must submit documentation from a licensed medical provider or other testing facility, confirming that the employee actually did test positive. Next slide, please. Another COVID topic, but there's a bit of good news here. Next slide, please. The New York State COVID-19 vaccine leave law is no longer in effect as of December 31st, 2023. And the New York City child vaccine mandate also sunset 1 year prior in 2022. So now employers are no longer required to provide leave for each COVID vaccine. So that's a little bit of good news. Next slide, please. And finally, we have a few updates on the New York State paid family leave front in 2024. Next slide, please. Okay, so this includes an increase to the maximum weekly benefit, but a decrease in maximum employee contributions. So under the law, employees are entitled to receive 67% of their average weekly wage, up to a cap of 67% of the state average weekly wage. And based on the state average weekly wage in 2024, the maximum benefit employees are entitled to is $1,151.16 per week, which is just about $20 more per week than last year. But on the other hand, employee contributions have decreased in 2024. So now the maximum amount of employee contributions is $333.25 in 2024. This is down about $66 from last year. Next slide, please. Finally, with a lot of employees still working remotely, a common question that we often get is, how does the New York paid family leave law impact remote workers? And the answer is now clear that to be eligible for leave, the employee's work must be localized in New York, meaning the work is performed entirely in the state, or if they work both in and out of the state, the work performed in New York State must be incidental to any other work. And then also there's a lot of activity on the enforcement of New York paid family leave. So these two sources here, the quarterly arbitration reports and the annual reports, are two great sources to just keep up to date on these type of things. But in sum, the total number of arbitrations are on the rise, as well as total claims paid per year. So there's no end to this in sight. All right, and now I will pass it off to begin the lightning round.
All right, well, thank you for that, Ashley. And yes, we're going to enter into the lightning round, so everyone roll up your sleeves. The legislature has enacted a veritable kaleidoscope of employment-related statutes over the last year. We're going to go through a whole bunch of them, and we're going to do it at a pretty high level, just to let you know that the statutes exist, what they say, and what your takeaways are. Obviously, if you have any questions about those, you can enter them in the Q&A box, or we're happy to speak to you afterwards if there's any nuance that we overlooked or specific questions you have. Next slide, please. So the first of these is the Freelance Isn't Free Act. It's part of the legislature's continuing focus on freelancers and independent contractors. And at a high level, what it says is that if you use contractors or freelancers in your business, you have to have a written contract with them. It goes into effect on May 20th, 2024, so there's time to prepare, and it will only cover contracts entered into after that date. So if you have someone with an existing relationship, you're arguably not covered by that statute. It only affects statutes going forward. It covers any contract for services valued at $800 or over in any 120-day period. There are very limited exceptions to this. And so if you have someone who comes to clean your home in New York and you pay that person more than $800 in a 4-month period, you arguably are also covered by this statute. Next slide, please. The only exceptions are lawyers, who often seem to like to exclude themselves from these statutes, doctors, salespeople, and construction workers. What's required is a written contract which specifies the names and addresses of the parties, the services to be provided, the rate or the fee for those services, and when the fee will be paid. So the takeaway here is if you engage contractors through a vendor or a third-party agency, you don't have anything to worry about, presuming that you have an agreement with that agency. If you hire them on a one-off basis, or you think that you have managers who are doing that, there may often not be a contract. It may just be an informal arrangement. That's the kind of thing that implicates the statute. And so you want to do a review with your vendor management team, if you have one, to make sure that you've captured all of the independent contractors that you have on your books. Next slide, please. The next statute we want to talk about was a tweak, more than a tweak, a real modification that the legislature enacted covering settlements and non-disclosure agreements when there are claims of discrimination or harassment. This has been a topic that the legislature has visited and revisited numerous times in recent years as part of the legislature's response to the Me Too movement. In this particular case, the modification to the statute covers any agreement with an employee or an independent contractor that's settling an asserted claim of discrimination or harassment. So that means the person has said to you, internally or externally, that they believe they were discriminated against or harassed, and you're settling that claim with a separation agreement, a settlement agreement, or some other kind of agreement involving a payment. So what's not covered by the statute? If you're entering into garden variety separation agreements where you're separating with an employee or contractor, they haven't made any claims of discrimination or harassment that you're aware of, it's just a normal separation, it is probably not covered by the statute. The statute is a little ambiguous. There are places where it implies that it only covers asserted claims. There are a couple of places where the legislature neglected to use that language, so there's a bit of ambiguity there. But we're fairly comfortable that it really only covers asserted claims and not situations where you're not aware of a claim. Next slide, please. What does it require? If you're settling a discrimination or harassment claim that contains a non-disclosure agreement, you can't impose liquidated damages if the employee violates the NDA. So what does that mean? Historically, these agreements have generally said, you agree that you won't tell anyone that we have this agreement, you won't tell them what we're paying you, and you won't tell them about the underlying circumstances or your claim. If you do, you have to give back all the money we're paying you. You can't do that anymore. You can include the provision if the employee agrees that there will be an NDA. You can't have the liquidated damages part that says they have to give back all the money. It's restricted to your actual economic damages if the employee violates the non-disclosure agreement. Still means you can sue them if they do that, if you decide that's what you want to do, but it may limit the amount of money you can recover from that employee because you're going to have to show actual damages that you sustained because they violated the confidentiality provision. One other thing the statute allows is until the statute was enacted, if you entered into an NDA settling a discrimination or harassment claim with an employee, there was a mandatory 21-day waiting period. You would give the employee the agreement containing the NDA. Even if the employee wanted to sign it immediately, you had to wait 21 days before they could do that. Now that's waivable if there is an actual claim. But if there's not a litigation. So if you're settling it internally before the employee has gone to court, you don't have to wait that 21 days if the employee doesn't want to. If there is a filed litigation because the employee has gone to court or the EEOC potentially, then you would have to wait the 21 days. Next slide, please. All right, social media access law. This is a law that says that you can't make people give you their password to Facebook and their other social media accounts, so you can go into those accounts and see what they're doing there, in effect. And it specifically says you can't require employees or candidates to provide their social media password or information as a condition of hiring, promotions, or transfers, or if there's a disciplinary investigation or process happening, you can't make them cough up their private social media data that is not publicly available. It means you can't request that they give you their login information. It means you can't request that they access the account while you stand over their shoulder to see what it looks like. It means that you can't tell them to go into it and hit the print button or download all of the content and hand it to you. If it is password protected or not public, you can't look at it. Next slide, please. It covers all employee social media and email accounts, even if it's accessed by the employee on a device that you provided to them. It doesn't cover your accounts. So if you have a Facebook page for your business and they say or do anything on that that you don't like, you have access to that, that's fine. And it doesn't cover any accounts or content that are public facing. Next slide, please. The legislature also enacted a statute relating to employee intellectual property rights. Historically, many employers have asked employees when they're onboarding to sign an agreement that says, if I invent anything, I give you rights to it, whether it has to do with the business of the company or not. What this statute does is it limits your right to an employee's intellectual property that they've created to things that they created on your time, using your resources or your trade secrets. If someone goes home and on a Saturday afternoon in their garage invents a better mousetrap, and you're not in the mousetrap business, then you have no right to that intellectual property. Next slide, please. What doesn't it do? It doesn't define the word invention, so it's unclear what an invention is. Is it patentable work or like a light bulb, or is it something that could be trademarked or designed or copyrighted? It also doesn't appear to provide a private right of action. The only action that the employees can take against you if you run afoul of this law is to complain to the Department of Labor. Your takeaway here is that you should review your IP agreements to ensure the scope is properly defined. If it's overly broad, you run a risk that the agreement could be set aside by a court if there's a dispute, and you don't want that. If you're a large employer, you may not want to review these agreements for your entire workforce, and that would be a waste of time because you're not worried about most of them inventing anything that you might care about. But there may be classes of employees like developers, or engineers who could do this, and it may be worth revisiting the agreements for those people, at least initially, to make sure that you've properly defined the scope. Also be mindful of the fact that in the post-COVID era, what constitutes work time has become ambiguous. In the old days, if it was, while someone was at the office, they were at work and that was all you had to worry about. Now that people are working odd hours at home under remote circumstances, that can be a lot less clear. And so that's something you want to think about as you review these agreements. Next slide, please. And the legislature also passed the Clean Slate Act, another revisitation of the legislature to background check issues, which it's visited numerous times in the past number of years. What the Clean Slate Act does is it seals certain conviction records and prohibits you from asking about them or looking at them. What is sealed? Misdemeanor records are sealed 3 years after completion of any sentence or probation, whichever is later, and certain felony records 8 years after the completion of any sentence or probation. Next slide. What's not sealed? Records of any Class A felonies, which are the really bad ones, like murder, rape, kidnapping, sex crimes, things like that. If the individual is still in their 3 or 8 year waiting period and they're charged with another crime, then nothing gets sealed. And what's not sealed also is any records relating to federal crimes or crimes that happened and were adjudicated in some other state. Who's not covered? If you run a business where you're required to conduct background checks for jobs involving children or the elderly, you're not covered. If you're required or permitted by law to run fingerprint background checks on new hires, as is the case in the securities industry, you're also not covered by the statute. And certain court and law enforcement personnel are also covered by it. Next slide, please. So what should you do? Review your application and onboarding process to make sure you're not reviewing sealed records. And if you use a third party to do this, make sure that you've made clear to them that that's your expectation. Ideally, that there's an indemnification in place if they don't get it right. And make sure that you have the proper processes in place so that you have the guardrails to ensure that you don't consider impermissible information when you run your background checks. And with that, I will turn it over to my colleague, Nick Lucier, for some more bolts of light.
Hey, everybody. So I want to talk to you really quickly about the New York captive audience meeting ban. And so this applies to unionized and non-unionized employers alike. So just because you don't have a union, don't think that this does not apply to you. So labor activity is on the rise. Say a trusted employee comes to you and says, a lot of people are really talking about unionizing. I think it's going to happen. All of a sudden, you call everybody into a meeting, say it's mandatory. You all have to be there. Well, you may now run afoul of not just the NLRA, but you will very likely run afoul of the New York captive audience ban. So backing up a little bit, the NLRA, the National Labor Relations Act, provides the ability for employers to speak about their views on unionization, provided you can't threaten people or have any sort of threat. But recently, the NLRB General Counsel, Jennifer Abruzzo, has made it very clear that she believes the law needs to be changed and that captive audience meetings should be always prohibited. And so, maybe a little bit uneasy or not satisfied with the progress that she's made, a few states have enacted their own state laws prohibiting captive audience bans. So states like Connecticut, Maine, Minnesota, Oregon have their own bans, and now New York has its own ban as well. There are challenges pending. One just started in Minnesota, and there's another one in Connecticut. Next slide, please. But under the New York law, as you can see, it is unlawful to take an adverse employment action based on an individual's refusal to attend an employee-sponsored meeting. And so you should, maybe consider making these meetings voluntary. That means you could schedule employees to attend, make clear in the invitation that it is voluntary, and then have the meeting anyway. The idea is that maybe the employees will go and, not really look into the voluntary part, and then you can sort of communicate your views. Again, no threats or use of force, anything like that. But you could, if you do violate this law, you could be subject to penalties, so keep that in mind. We can move to the next slide. Perfect. So this one is pretty quick. The New York State Human Rights Law has been amended it's been harmonized really to provide for a 3-year statute of limitation on discrimination and retaliation claims brought under the statute. It applies as of February 15, 2024, only prospectively, so not retroactively, but only prospectively. So things that accrued as of February 15, 2024 will now see the 3-year statute of limitations going forward. Next slide, please. The New York City Workers Bill of Rights. I'm going to be talking about a couple Bill of Rights, so sorry, but get ready. So there's a notice requirement effective July 1st, 2024. Beginning on that day, employers need to provide employees a copy, a posting of the New York City Workers Bill of Rights notice informing employees of their employment rights. We are expecting that is going to be posted any day now. I believe there was a March date set in the law that it would be made, but just keep in mind that's coming down the pipeline. And also keep in mind that if you're a remote employer, have lots of remote employees, you will be required to distribute that notice electronically or post it on your intranet, what have you, in a way that allows employees to actually view the posting. Next slide, please. So, New Jersey Temporary Worker Bill of Rights. Here we are. We're talking a little bit about New Jersey. The law, broadly 10,000-foot view, regulates temporary health service firms in New Jersey, but also their third-party clients, and the New Jersey Department of Labor is interpreting this broadly. In fact, their proposed regulations discuss having if a temporary laborer is a resident of New Jersey and working in New York, they are going to construe the law such that New York-based third-party clients have to comply with the law. And there are record-keeping requirements. There's joint liability on a pay equity provision. And this is something that, there's a lot to this law. It's not a lot we don't have a lot of time to cover everything, but I want you to be aware of it because the New Jersey Department of Labor, I know, is actually actively looking at this right now, and they're taking an enforcement posture despite the fact that the regulations aren't even finalized yet. So with that, I'm going to turn it over to Daniel.
All right, thanks so much, Nick. If you thought we were in the lightning round before, we have now entered the final phase of the real lightning round. And very quickly, turn to the next slide. In early 2023, New York has issued a revised model sexual harassment policy. Mandatory sexual harassment policies have been in place in New York since 2018. In 2023, this was the first major substantive modification by New York. You'll see on this slide and the next slide are the statutory requirements for what's required to be in a policy. The main takeaways, moving to the next slide, is these are our takeaways of the major changes that were enacted, that were included in the new model policy. And I bring that up because I've gotten a lot of questions about, do we need to use word for word the new model policy? Likely word for word is not unnecessary, but if you're going to veer from the model policy and have your own, we strongly recommend you at least touch on, if not have a good discussion about these main topics, because these are the themes clearly that the New York State Department of Labor was pushing for in making this new model policy, and that's what they'll be on the lookout for to ensure compliance. All right, moving to the next topic. New York City added a new protected category that went into effect in November 2023. That is weight and height discrimination prohibition. Moving to the next slide, we'll see that there's some different examples of what exactly could be a potential adverse action that is discriminatory. Again, that rejecting an applicant based on these requirements, including in a job advertisement. And this is coming from the New York City Commission on Human Rights, which put out some guidance on the topic. Let's move to the next slide. There are some potential exceptions if these limitations are required by federal, state, or local law regulation. That could be that's just excluded from the discrimination prohibition. There are other regulations that should be coming out at some point from the commission, identifying categories of jobs that might be excluded from this. But as far as I saw earlier today, they have not done so. The last thing I want to note on this is on the next slide are that there are some affirmative defenses that an employer can assert to avoid liability. The one includes this idea that there's no alternative action. If the employee cannot perform the essential functions of the job without accounting for this weight and or height issue, then the employer has to maybe take an alternative action. This is where it gets a little bit more complicated. It sounds like language of reasonable accommodation. The commission notes it's not the same as reasonable accommodation. But their guidance is a little bit wishy-washy on that front. They note it could be similar to the reasonable accommodation process. However, they say explicitly a cooperative dialogue required under New York City law is not required to get to the stage of determining whether an alternative action is. So there's a lot to unpack there, but again, just high-level overview. And the last part that I want to talk about is some changes to unemployment programs in New York and New Jersey. With New York specifically, you'll see we have the form here for you. This went into effect in November of 2023. New York has put out a new form that complies with new statutory obligations for the notice of entitlement to unemployment benefits. Make sure that you're using this form now as opposed to the form that was in place before. Okay, in New Jersey, just to touch on that, also in 2023, New Jersey, there was a whole lot of changes that they put out, but it's very much a work in progress. That's the big takeaway. There's, if you go on their website, there's extensive FAQs where they sort of emphasize it's a work in progress. They don't have the full system in place to ensure the electronic correspondence that's required, but there is a sign up for a particular employer access portal that they have that they're going to be using to communicate with employers. So you make sure that you're registered there. There's certain forms that they have still not published that should be necessary to comply with the law, and they've noted that they're going to have leniencies until that comes. And the next slide just emphasizes the increased penalties that are in place. Before, it was $20 fine for every 10 days of failure to comply, whereas now both each and every day and each and every failure could be its own failure, and the penalties go up significantly from there. So again, there's lots to unpack, but turning to Rob for the last substantive topic.
All right, thank you, Daniel, and thank you everyone for sticking with it. I know we've thrown a lot at you, but again, we will be circulating the slides, so you'll have all this for your ready reference. The final topic is brief, and fortunately, it's something that didn't happen in 2023 that we all thought would happen, and it seemed like it was almost a certainty. In June of 2023, the New York State Legislature passed a sweeping prohibition of non-compete agreements, almost no exceptions, did not have any salary minimum, did not have any exception for the sale of a business, just an outright prohibition. That then ensued 6 months or so of compromise discussions between the legislature and Governor Hochul. Those did not result in any compromise, and so in late December, Governor Hochul vetoed the bill. As of this point, nothing new has been introduced in the new 2024 legislative session, but this is another topic that we are keeping a close eye on because it did pass the legislature with quite large majorities. So we do expect there will be some further action on this subject sometime in the coming months. With that, we are at the end of the webinar. I will now give you the CLE code, which is SS6574. That's SS as in Seyfarth Shaw 6574. And with that, we thank you all for joining us today. We hope this has been helpful. If we were not able to get to your questions in the Q&A function on the webinar, we will reach out to you separately and do our best to answer that for you. And of course, you can always reach out to any of us for any follow-up questions. Thank you very much and have a great rest of your day.